attorney and an estate planning attorney. I have a significant focus in working with individuals that have special needs and then the family members who are also caring for them. I'm going to make sure my little screen, I'm trying to advance my PowerPoint presentation here. I often get the question, it's like, well, Ms. Hemness, you say you're also an elder law attorney, because I am board certified in elder law. I'm only one of maybe about 125 in the state of Florida that have that Florida Bar Board certification in elder law. And they say, well, why, if I am working with my child who has special needs, why would I be looking for an elder law attorney? It's because, just very simply, what we have is the same body of law, whether federal or state laws, governing an elderly person who becomes disabled as they age, incapacity, mental, physical incapacities, or something along those lines. That body of law is very similar to those individuals who have been born with a disability. So that's the reason why an elder law attorney is uniquely talented or knowledgeable in those areas of law. I also have an additional distinction. I'm a member of the Special Needs Alliance. This is a national invitation-only organization dedicated to working with the individuals who have special needs. So this is an attorney organization. It's an alliance nationally. So if you were to leave the state of Florida, then what you could do is you could probably find one of my colleagues in another jurisdiction. With that said, a lot of people say, well, why am I not working with a social security disability attorney? It's usually that you would be working with an elder law attorney or an elder law attorney that has a specific special needs law focus, rather than a social security disability attorney. Usually social security disability attorneys only will get involved when you've actually had maybe your child denied for SSI benefits or something along those lines. But the actual planning that a parent may do, with this workshop being called What You Should Know to Protect Your Child, from an estate planning and special needs trust viewpoint, you're really going to be working with a special needs lawyer or an elder law attorney. So I just wanted to clear that up. Now, a lot of things happen that you need to understand, and as a backdrop, so that you can understand why, as a parent, you may need to do certain things in order to protect your child, particularly doing some estate planning and then understanding what would be the makeup into your estate planning. And it's like, well, things change when your child turns 18. Because you as a parent, you've enjoyed up until the age of 18, you've enjoyed the ability to make decisions on behalf of your child, but miraculously the law recognizes your child at the age of 18, so they are supposed to be able to make their own decisions. And so they are a legal entity separate from you. You are no longer, quote unquote, the parent in terms of what you have the ability to decide on a legal foundation basis, even though you're still doing the same thing as you did at, the 17th birthday at 364 days. You're still doing exactly the same thing when your child turns 18, but you lose that status of a parent. And I'll get more into that. That's the second part of what you should do to protect your child, part 2. That's my program. That's my lecture that I'm going to be doing on Tuesday, this coming Tuesday afternoon, when I'm starting to discuss guardianship and some other issues when your child turns 18 and some of those challenges that you have. But I also want to go and say, okay, what you do to protect your child kind of focuses back on what your child is capable of obtaining when they turn 18 and get outside of your umbrella. The primary programs of assistance that we see is going to fall under the Social Security benefits world or your state Medicaid programs. In the universe of Social Security benefits, when a person is disabled, there's 2 disability benefit programs. There is the Social Security Disability Program, okay? So that's with individuals who've had a work history and prior to retirement, they suffer from a disability and then they seek early retirement, but that is actually in the realm of a disability benefit. But then there's individuals who have not been able to get a work history or have very little work history because of a disability. And then so we have a program that is supportive of those individuals, and that program is a supplemental security income program. So that's what we call SSI. So understanding when your child turns 18 and they come out from underneath your umbrella where your income and your assets are diminishing their ability to get this benefit, when they turn 18, they come out from underneath your umbrella, they can obtain SSI benefits on their own. Now, currently, the SSI full benefit rate is $794 a month. In Florida, we're uniquely called a 1634 state under the Social Security Administration federal laws. And 1634, that section just basically says that if your child gets just even $1 of SSI, that $1, that $794 a month, if they get $1, then automatically, like as a piggyback to the SSI benefit, Florida Medicaid will provide them health insurance. Now, when I say Florida Medicaid, let me distinguish, that's the health insurance side, and that's not the special supports and services that we would get through the home and community-based waiver programs, the developmentally disabled waiver program, which many of you know have long waiting lists. And I'll touch on that in just a couple slides out. But in order to trigger the supplemental security income benefit, you have to provide enough evidence to the Social Security Administration that your child has a disability. And it's also means tested, which is kind of a fancy way to say you got to be poor. Your child has to be poor, not you anymore, but as a parent, but your child has to be poor. But there's certain things that do not count in that poorness criteria. So 2,000 or less in countable assets, but then there also could be other assets that are considered non-countable. So according to the SSI rules, a house wouldn't be countable, its contents wouldn't be countable, having one car for transportation would not be countable, so those values are not countable. But then we also know uniquely, and this is really where I'm going to target in on what you should do as a parent and how to protect your child, is dollars that you have set aside are dollars that are in special needs trusts and how those trusts are configured. Also dollars in ABLE accounts. So I will go over both of those. Other things that you need to be aware of, and again, I was saying earlier when we were doing our meet and greet, and it's kind of funny. We got our rules, we got our exceptions, and then we got the exceptions to the exceptions. So this is very heavily intensive in what the rules are and what the laws are. But when an individual has SSI, then they may lose SSI, and this will occur. And if you, as time goes on, don't be surprised that when you as a parent either retire or if one of you pass away, if we've got two parents and one of you pass away, or if you become disabled yourself, your child will lose their SSI. But that's not the end of the story. It may mean a bit better benefit, but SSI would then be lost, and that their child may actually end up with a disabled adult child benefit from the Social Security Administration. And that's usually a bigger benefit, and it's not a means tested benefit. So we don't have to prove poorness anymore for that benefit. And that benefit actually is paid on the basis of the parent's own work history. So it's not unusual for me to see $794 of an SSI benefit jump up to $1,100, $1,200, $1,300 a month because a parent has either died or retired. But there's always these pitfalls if a higher functioning child decides to marry, then that benefit is also lost. So again, these are things that we need to be careful about and always see and pay attention to, because what you don't know could possibly hurt you or hurt your child. Also, when we do have a loss of the SSI benefit because a parent retires, dies, or becomes disabled themselves, and we get that disabled adult child benefit, It's a bigger benefit. We got more money coming in. It's not means tested. We would ultimately lose Medicaid. It doesn't mean that's the end of the story. Also, Medicaid from a health insurance standpoint could be gotten back. But here's a bigger benefit. After having the disabled adult child benefit for a period of 24 months, then your disabled child would then have Medicare. Actually, Medicare, because Medicare is a health insurance program covering individuals that are 65 and older. But guess what? Your child would also have Medicare, and that would open the universe up for them getting to be able to see far more physicians, far more specialists, because Medicaid we know Medicaid, seeing a specialist is very difficult to find a specialist that will accept the Medicaid reimbursement rate. But Medicare, however, would be tacked on to when your child were to receive that disabled adult child benefit. The Medicaid programs of assistance, I've already touched on those. That Medicaid would be our health insurance program, our general health insurance program. Medicaid health insurance is always going to be secondary. It's going to be the payor of last resort. So anything else, TRICARE, any private insurance that you may have through your employer as a parent, being able to cover your child up to at least age 26, and then Florida extended that to age 30. Those Medicaid is always going to run in the background. It's always going to be the payer of last resort. Another form of Medicaid that we have, of course, in Florida, also falling under that Medicaid umbrella, would be the developmental disability waiver. That's a home and community-based program, and that's the program that ultimately we really want to have for our child, because it provides us supports, the personal support, the life support, and then services, transportation, things along those lines. So the unfortunate aspect is, we all know that to be on this waiver, it's a long list, and waiver just means where this is not an entitlement, and that it is really truly dependent upon, those lists are dependent upon how much budget, how big the budget, how much money our legislature actually devotes to this budget. And in order to get on the list, and you should get on the list, you would contact the the Agency for Persons with Disabilities, or we abbreviate that APD. They are the agency that contracts with our state of Florida in order to manage those waiting lists, and then coordinate those supports and services when a person is ultimately approved for those services. But really, the focus of the presentation today is, making sure that you're doing as a parent what you need to do to protect your child that has a disability, and that may need these benefits moving on into the future. So it's important to look at what steps do you need to take to prevent, the possibility that you would actually be the one inadvertently from, actually causing your child to be denied these support benefits. These are very important benefits to, keep their quality of care, keep their quality of life moving forward. So what would we otherwise want to make sure that we were doing? Well, as a parent with a child with a disability, you would want to do the same thing everybody else should be doing. We should be establishing an estate plan. It's just that the estate plan that you would traditionally establish, you would then be making sure that it was tweaked, or there was an element of it that specifically addressed what you're doing for your child with special needs. And most of the time, that's going to mean, right there down at the very bottom of the slide, implementing some form of a third-party special needs trust. So you do the same thing everybody else needs to do by getting a power of attorney, getting a designation healthcare surrogate. If you don't want to be kept alive on tubes forever and ever like Terri Schiavo was, you would get your own living will to say what you want at end of life. But when we're talking about what happens after you're gone, how do I leave an inheritance to be able to make sure my child has, plenty of money, but also have care, and expenditures, and not disrupt SSI or disrupt Medicaid? How do I do that? Well, we would be using a third-party special needs trust for that, for making sure that occurs. So this part is, I call it the ABCs, P's, Q's, the special needs trust. So again, it can be very involved and it can get very confusing. So I created like a little rule. If you are looking at a special needs trust and you know that I've got to get one of these, so that I can protect my child, or I can protect money for the benefit of my child without that money being counted against them, that will reduce their benefit or knock them off their benefit. There's one secret. There's one secret that you always keep in the back of your mind, and you'll know exactly what type of special needs trust that we're talking about. The secret is follow the money. If you follow the money, whose money is it? If you follow the money, then you will know exactly what type of special needs trust that you need to be using. So if we are using a first party special needs trust, a first party special needs trust inherently has a payback provision in it. A first party special needs trust, let's examine that for a second. First party, what does first party mean? First party means it is the money that belongs to your disabled child. Your disabled child is the first party. So what would go in a first party special needs trust? Only the money of the disabled child. So that would be anything that the disabled child, like if grandma gave the disabled child $100 and made the check payable directly to the disabled child, if grandma passed away and left a CD paid on death to the disabled child, if the disabled child doesn't use all of his or her SSI benefit monthly and wants to accumulate some money, that money, the savings or the accumulation comes from the SSI benefit that belonged to the child. This is all first party money. This is because the money belongs to the disabled child or has originated from money that belonged directly to the disabled child. So with a first party special needs trust, one of the federal law provisions is that at the time of death of the disabled child, if there's any money in this special needs trust, he has to go back to pay Florida Medicaid or the state in which Medicaid benefits were achieved. So the beneficiary of a first party special needs trust at the time of the child's demise is the state. So we don't want anything going in a first party trust that doesn't belong in a first party trust, because we got this clawback by the state of any dollars and for any benefits received during the lifetime of the child. So again, we are just, we're focusing on, if we're following the money, then the first party special needs trust, the only money that would ever go in this type of a trust would be the disabled person's money themselves. And I know that slide is all, has a lot of information on it, but, that's what I'm just explaining is that. And then the number one thing is, upon the death, it will pay to the state before there's anything else that can be paid. Anything in these trusts, though, because it is a special needs trust, we do have the knowledge that if there is money in these trusts and it can be used out of the trust for the benefit of the disabled child for any of their disability expenses, any of their supplemental needs, and while it's sitting there in the first party special needs trust, it will not hurt our SSI benefit and it will not hurt our Florida Medicaid benefit. Going to third party special needs trust and emphasizing third party, who would a third party be in relation to the disabled child? If the disabled child's money should always go in a first party because they're the first party, who's the third party? That would be anybody else. Anybody else is a third party if it's not the disabled child. So where does money, follow the money, where does money of a third party go? Third party money should only ever go into a third party special needs trust. So a parent is a third party. So if you want to take your money that you earn from wages, your income, your salary, and you want to set up a savings account to start to accumulate a savings account for the benefit of your disabled child, then where are you going to put that money? You're going to put it in a third party special needs trust because it was your money. It was your money and you're a third party. There's some other options, and I'll get to those in just a moment. That being the case, You just want to know that you would otherwise use a third party, and that's a third party special needs trust that can be embedded in your estate plan or become part of your estate plan as a key component. Because when you pass away and you want to leave an inheritance to your special needs child, it's your money, you're dying, you're leaving an inheritance. It needs to go into a third party special needs trust. And once again, the third party special needs trust would have a trustee that would be the money manager that could dole it out for things that your child needs throughout their lifetime. Anything in that trust up to any amount. So it could be a bazillion dollars in this third party special needs trust. That will not impact SSI. It will not impact Medicaid, but yet we can still use that. And then at the time of demise, if we've had the child be the beneficiary of this third party special needs trust throughout their entire life, but there's money left over, at the time of demise, there is no payback to the state. There's no clawback by the state because it's third party money. The state is not entitled to be a beneficiary of that trust. Other siblings, if you have other children who are not disabled, that they could be the inheritors. You can leave it to charity, you can leave it to your church, you can leave it to anybody you choose to, because the state is not going to be a beneficiary. And you are the one who is setting forth in your estate plan who the third party special needs trust is for, your disabled child. And then if your disabled child is no longer with us, you're also setting forth where that leftover money goes. And we know that there's no clawback by the state of Florida. So with that said, where do we put the third party special needs trust language? So special needs trust is language that says what these dollars should be used for. It sets forth, who the trustee is. It says what we can spend the money on for the benefit of your disabled child. And it says what happens after your disabled child is no longer with us. We can take that language and we can put these trusts, and we can put them in your will, your last will and testament. We can put that into a revocable living trust, or we can create the darn thing. We can create it right now, sitting there, language, and you can immediately, it gives us a title, and we can immediately go open a savings account in the name of that special needs trust. So that last one that I just referred to, we call the third party special needs trust. That is a standalone trust because it's third party money that we're putting in it, your money, grandma's money, anybody's money other than your disabled child's money. We're putting third party money in it, but if it's a standalone, it means you've created it, it exists right now, and you can go out and create a brokerage account in that name. You can set up a CD in that name. You can do anything you want to because it exists right now. That's compared or in contrast to if you had a third party special needs trust that was in your will, then it doesn't exist until you're deceased. Okay, so a will takes effect only upon your death, and then that particular trust, if it's in the will, only wakes up when it's receiving an inheritance for your child, and it limits your opportunity to try to set money aside right now, here and now, as you go along through a lifetime. But a third party special needs trust, wherever it is, it will be able to hold an unlimited amount of assets as you go along. This is what I was alluding to, is the standalone third party special needs trust, where you can create it now. If you create it right now, it's like a living animal entity, and then you can once you do the heavy lifting and you create this that is part of your estate plan, then you can go out to grandma and you can say, hey grandma, guess what, if you want to change your will to say you leave something, look what I've done for you. I've got a title, I've got this trust, I've already got it set up. All you need to say is, I leave this to the third party trust created for the benefit of Adam Jones. And it also allows you with life insurance policies to beneficiary designate and name trust. You can put your IRAs and beneficiary designate your IRAs to it. But again, more importantly, if you do have those relatives that do want to leave something to your disabled child, you've already done the heavy lifting and you've given them a name that they can just change, simple change to their will, simple change to their revocable living trust, simple change to, pay on death on a CD at a bank account. Any one of those things, you are able to then give that to them and they are able to make it easier. So we also have, some peculiar situations from time to time. I work with, individuals who are military retirees. I call it a peculiar situation because it kind of goes against my follow the money rule. And so again, this can get somewhat complicated, but if you had a retirement benefit from the military, then we can, even though it's like your pension and you're leaving a benefit after you've passed away to your surviving disabled dependent, there is only one type of trust we can use in that circumstance. And this is by law and by the Department of Defense. They did a memo and they said we would have to use in that circumstance a first party special needs trust. Even though you may be the military retiree and you die, and then it's your pension going to your disabled child, it is only since it's going to become the disabled adult, disabled child's money because they're going to receive that pension benefit. That then means it's their money. It has to go in a first party trust. So there's a whole nother universe out there for anybody that would, be in the military, have a military retirement. We, again, we have to just watch those particular situations, but there is a solution now, which did not exist just a few years ago, on how we can handle. We are actually, I've been involved in some legislative, efforts to allow teachers' retirements, any Florida retirement, they will not allow you to name a trust. And we're trying to get the Florida retirement system to recognize what, Department of Defense has already recognized and allow us to actually name a first party special needs trust for any retirement benefit under the Florida retirement system. The other thing that what I want to clarify for is how you are helping set aside dollars or can set aside dollars. And a lot of people compare and contrast ABLE accounts to a third party special needs trust. An ABLE account is kind of like this bizarre hybrid between first party money, your disabled adult child's own money, and your money where you would otherwise put it in a third party special needs trust. Here's a simple opportunity, and you can create this at any time for the benefit of your child. It is a tax preferred account. It is under the Internal Revenue Code section of 529, because we're familiar with 529s being educational savings accounts with tax preferred status. Well, back not too long ago, ABLE accounts were then created, and it allows you or anyone to put aside up to $15,000, which is the annual gift tax exclusion for 2021, $15,000 per year into these special savings accounts. The uniqueness of an ABLE account is that we can only ever create one account for the one child, and we can never put more, no contributions to exceed $15,000 in any 1 year. But it's a perfect opportunity that on a monthly basis, if your child's getting the max SSI benefit of $794 and they don't spend it all, and yet we have to keep their total countable asset below 2,000. What do we do with that extra money when we're looking around and we don't know how to spend the money, but we want to save it? We can put it into an ABLE account. So the ABLE account will be able to receive first party money, that is the disabled child's money, and it will also be able to receive your money, third party money, if you want to put that in there also. So either an ABLE account is kind of an odd hybrid, and it kind of functions very much like a special needs trust, like a baby special needs trust, but we can put either third party money or first party money into these ABLE accounts. When an individual dies who owns an ABLE account, and certain states have ABLE accounts also. Florida created its own. You can find, if you Google Florida ABLE, then it'll take you to the website, www.ableunited.com. And then it'll probably take you about 10 minutes to set one up online. But if you haven't gotten your estate planning done, but you want to start saving some money for your child, this would be the perfect opportunity to do it. Some people ask, well, why do I need the third party special needs trust if I can put the money in the ABLE account? Is that when you die in particular, you can't, if your IRA would exceed 15,000 or your life insurance would exceed 15,000, or you want to leave your child, the equity in your home and that would exceed 15,000, you just got to remember ABLE accounts are always capped at 15,000. And even as you accumulate more dollars over time in the ABLE accounts, a disabled person will lose their SSI benefit if it exceeds $100,000 at any point in time. Other restrictions on ABLE would be, someone has to have their disability manifested before the age of 26. But we do have the ability to spend on all disability benefits. So if we had qualified disability expenses on behalf of the child, we have money in the ABLE account, we certainly could spend it at any time. And Florida has taken, by legislative action, ABLE accounts had that clawback, that a state could be claw back dollars against the ABLE account when the person died. Our Florida legislature has actually promulgated a law that says Florida will not claw back any dollars in the ABLE account. So that's our current status. So that's actually very beneficial. So I kind of talked fast to make sure that we had plenty of time for questions. So